Hello, good afternoon. Welcome to the annual Dame Frances Patterson Memorial Lecture, this year brought to you virtually, despite our best intentions to have done this last year in the autumn. I particularly welcome Frances' husband, Graham, and their sons, Oliver, Leo, Simon, and also Frances' sister, Rosie, who I believe is joining in virtually from Australia. So I think it's around 4 a.m. for where she is at the morning. This time of the morning, so good morning to you. The fact that this event is being held virtually doesn't dilute, in my view, in terms of the significance and importance, as this year, following the footsteps of our last speaker, Baroness Hale, I invite Lord Lloyd-Jones to present his paper on the Law Commission, the courts and the law reform. But before I introduce him, it would be amiss, in my view, if I didn't say a few words about Frances. Frances went to school in Chester before heading to university to study combined arts, where she met Graham at university. She graduated in 1975 and studied law at what is now known as City University in London before being called to the bar in 1977. She joined Chambers 2 years later and then became its head of Chambers some 25 years later. Along the way, she took silk and was elected a bencher of the Middle Temple. She was also published. We wrote and edited a book together on judicial review, and her name remains in its title as the legacy of her contribution to the regionalisation of the administrative court. Latterly, Frances was a commissioner for public law from 2010 and 2013, and the reports of the commission during that period included adult social care, resulting in the Care Act of 2014 and Public Services Ombudsman, amongst other things. In 2013, she was appointed to the High Court and the lead judge for the Planning Court latterly. I asked Philip Rayner, previously his Honour Judge Rayner QC, about Frances, who sadly can't be here this evening, but he said this in an email to me. Sam, as you know, Frances was my first pupil when I started the bar only 6 years in. It was obvious to me from a very early stage that she would have a glittering future. In about 1982, we co-defended 2 young men at Derby Crown Court who were accused of stealing Blue John from a Blue John mine. Their ambitious defense, he said, was that they thought the stone had been abandoned in the mine. At the end of the trial, my defendant, Philip said, was convicted and Frances's was acquitted. Afterwards, when I went to see him in the cells, his first comment to me was, "That Miss Patterson, she's very good, isn't she?" Philip ends the email saying, "Never was a truer word spoken." There's no doubt that Frances would have continued up the ranks in the judiciary, but sadly that trajectory was cut short in late 2016. This memorial series of lectures seeks to recognise her outstanding contribution to planning and public law. And so can I take this opportunity to thank all of those who have organised this event this year virtually, in particular Mark Ronson, who's our senior clerk here at King's, and those individuals who I sat down with in 2017 when we came up with this idea, namely Bill Brown, who has since retired as our chief clerk here at King's, Michael Kaplan, who is also senior clerk, who's also retired from 39 Essex, and Richard Wilmot Smith, QC. So now to today, and our outstanding speaker who requires, again, in my view, little introduction. He attended Downing College in Cambridge and was a fellow of that college from 1975 to 1991. At the bar, his practice included international law, EU law, and public law, and he took silk in 1999. One of the many highlights of this career included him being the amicus curiae, the independent advisor to the court in the Pinochet litigation before the House of Lords as it then was. Lord Lloyd-Jones was appointed to the High Court in 2005, and from 2008 to 2011 served as a presiding judge on the Welsh Circuit. In 2012, he was appointed a Lord Justice of the Appeal, and from 2012 to 15, quite a chronology, the chairman of the Law Commission. And then he became the Justice of the Supreme Court in October 2017. We'll be able to take 1 or 2 questions at the end of our session today, so please use the question and answer tab at the bottom right of your screen. But for now, on behalf of King's Chambers, on behalf of 39 Essex and the Planning and Environmental Bar, I'll hand over to our guest speaker, who I'm very grateful has invited our invitation to speak this afternoon.
There's no Calends in the Greek calendar. Accordingly, waiting for the Greek Calends conveys the sense of waiting for something that's never going to happen. A bit like waiting for Godot, I suppose. It may have occurred to some of you in the audience this evening that this is an appropriate title for this lecture given the events of the last year. You may have wondered whether this lecture, which was intended to be delivered a year ago, was ever going to happen. It's a great honour to be invited to deliver the second Francis Patterson Memorial Lecture, and I'm delighted that through the perseverance of the organisers, it's possible to deliver the lecture this evening. I had the privilege of working with Frances at the Law Commission, where she was, quite simply, a brilliant colleague. Before I joined the Commission, I was already aware of Frances's reputation as a highly successful silk on the Northern Circuit, with particular expertise in planning matters. When I was appointed chairman of the Law Commission in 2012, it immediately became apparent to me what an outstanding law commissioner she was. She combined a formidable intellect and a very wide legal knowledge and interests. She was immensely hardworking and enterprising, and she was extremely well liked. At the Commission, she was the commissioner responsible for public law, which included some massive projects. Sam's just mentioned two. They also included regulation of healthcare professionals, taxis and private hire services, wildlife regulation, and electoral law. The taxis project caused Frances and her team to undertake some original research with the assistance of the police in Liverpool on a Saturday night, an adventure which became legendary at the Law Commission. The taxis project also proved highly controversial, and I well remember being cross-examined by the then Lord Chancellor as to why he was seeing stickers in the windows of taxis declaring no submission to the Law Commission. Frances was, of course, an ideal candidate for appointment to the High Court bench, and it came as no surprise to any of us at the Commission when she was appointed to the Queen's Bench Division in 2013. Our delight at this news was only slightly tempered by our sadness at losing her as a Law Commissioner. I well remember a telephone conversation with the then Lord Chief Justice, Lord Thomas, as to when she was going to start her new job. We both knew what an asset she was to our respective organisations. Frances immediately established herself in her new role, showing those legal and human qualities for which she was already well known at the Bar and at the Commission. She was clearly destined for even higher judicial office, and it's a tragedy that she was not spared to fulfil those expectations. We are, however, left with the memory of an inspirational colleague and a wonderful friend. It's a particular pleasure that Frances's husband, Dr. Graham Nicholson, and their sons Oliver, Leo, and Simon, Frances's sister Rosie in Australia, good morning Rosie, and many of Frances's friends and colleagues, including many friends from the Law Commission, are able to be with us this evening. And I send you all my warmest greetings. The invitation to speak this evening has caused me to look back at the time I spent with Frances at the Law Commission and to reflect on the Commission's role. My term as chairman came to an end in 2015, and the slight distancing in time is perhaps useful in this regard. And as part of this process, I've been led to reflect in particular on the role of the Commission in relation to law reform effected by the judiciary. Every legal system must possess the ability to accommodate the changing needs of the society it serves. Today, the accelerating speed of change in the modern world constantly throws up new challenges for the law, not least as a result of technological and scientific change, and as a result of changing moral and social attitudes. Law reform, therefore, really matters. In particular, it has the power to improve the quality of people's lives and to provide the conditions under which trade and commerce can flourish. It may be that this importance is not sufficiently appreciated in this country. The primary duty of the Law Commission of England and Wales, an independent body created by Parliament in 1965, is to take and keep under review all of the law of England and Wales with a view to its systematic development and reform, including in particular the codification of such law, the elimination of anomalies, the repeal of obsolete and unnecessary enactments, the reduction of the number of separate enactments, and generally the simplification and modernization of the law. The scope of this duty has been described by one academic writer, Professor Cretney, as breathtakingly wide. The work of the Law Commission is very much focused on law reform through legislation. Throughout its existence, the Commission has had in-house parliamentary counsel, and it's a striking feature of its work that most of its law reform reports are accompanied by a draft bill which would implement the recommended reforms. The advantages of parliamentary legislation as a means of achieving law reform are obvious. In particular, legislation makes it possible to put forward a coherent and relatively complete statement of the law in an accessible form. However, legislation is not always attainable. Perhaps understandably, law reform has not been particularly high in the agenda of successive governments, and there's great pressure on parliamentary time. If we take all of the law reform reports of the Law Commission over the past 56 years of its history, approximately 2/3 have been implemented by Parliament in whole or in part. On the face of it, a respectable rate of implementation. However, the average conceals the patchy nature of what has been achieved. In the early days of the newly created Commission, under the leadership of Leslie Scarman, there was, as could be expected, a high rate of implementation by the government which created the Commission. More recently, the implementation rate fell decade on decade, with the result that at the start of the 20th century, the implementation rate was in the region of 40 to 50%. Sometimes the Commission's recommendations for law reform did not gain government support because there were disagreements on policy. However, there have been many other instances where proposals failed because of a lack of parliamentary time, a lack of resources, or because the government of the day did not see them to be a priority. During his term as chairman from 2006 to 2009, Sir Terence Etherton was able to persuade the government of the day to introduce measures which were effective in reversing the trend, at least for a time. First, the Lord Chancellor and the Law Commission agreed a protocol, as a result of which the Commission will now not take on a project unless there's an undertaking by the relevant minister that there is a serious intention to take forward law reform in this area. Secondly, under the Law Commission Act 2009, the Lord Chancellor is required to make an annual report to Parliament on the implementation of Law Commission proposals. And thirdly, a new streamlined procedure was adopted by Parliament in 2010 in respect of non-controversial Law Commission bills, and 8 England and Wales bills and 1 Scottish bill have now reached the statute book under this special procedure. So the machinery is in place to permit the enactment of law reform by legislation, and it's been shown to be capable of working efficiently. There remains, however, the problem of a shortage of parliamentary time. In addition, the reforms recommended by the Commission, while important, may be relatively technical in nature, and this may help to explain why they're not high in the political agenda. The failure to appreciate the importance of law reform is not a problem unique to this jurisdiction. Similar problems have been encountered elsewhere in the Commonwealth. In Australia in 2006, in a famous dissenting judgment in Clayton and the Queen, Michael Kirby, Mr. Justice Kirby, a most distinguished law reformer, said that waiting for a modern parliament to grapple with issues of law reform is like waiting for the Greek Calends. It will not happen. He added that eventually courts must accept this reality and shoulder their own responsibility for the state of the common law. To what extent, therefore, should the judges step into the breach in order to reform the law? There is, of course, a current debate among lawyers and among the wider public as to the extent to which unelected judges should act to change the law. Judges undoubtedly lack the seal of democratic approval enjoyed by elected politicians. Widely differing views are held, including among the judiciary, as to the appropriate limitations on judicial law reform. A recent formulation, which I think has a lot to commend it, is that of Lord Reid in El Ghazouli against the Secretary of State for the Home Department, where he said this, I quote, "I fully accept that the common law is subject to judicial development, but such development builds incrementally on existing principles. That follows from two considerations. The first is that judicial decisions are normally backward-looking in the sense that they decide what the law was at the time, which is relevant to the dispute between the parties. In order to preserve legal certainty, judicial development of the common law must therefore be based on established principles, building on them incrementally, rather than making the more dramatic changes which are the prerogative of the legislature. Following that approach, new rules may be introduced or existing rules may be reformulated or departed from, but the courts continue to apply principles which formed an established part of the law at the time of the events in question. The judges are then faithful to their oath to do right to all manner of people after the laws and usages of this realm. Secondly, that constraint on judicial lawmaking is also compatible with the preeminent constitutional role of Parliament in making new law, and with the procedural and institutional limitations which restrict the ability of litigation before the courts to act as an engine of law reform. And in that case, the majority, Lord Kerr dissenting, rejected a submission that the common law should be developed so as to include a prohibition on the facilitation of the death penalty in a foreign jurisdiction. Most would agree that the position of the judiciary within our constitution does impose some limits on the freedom of judges to change the law, although it's usually far more difficult to define with any precision where the line should be drawn. It may well be that defining appropriate limits will depend on the particular context. Although many may have concerns about judges changing the law on a subject as controversial as assisted suicide, for example, which has long troubled Parliament, I doubt that they would necessarily feel the same way about the judges taking the initiative over the reform of the illegality defense to civil claims or the law on equitable estoppel, or other matters in which Parliament has shown no interest. But it goes further than that. Few, I think, would doubt that the judges do have a basic responsibility to maintain the state of the common law and to maintain it in effective working order. In the Queen against Jogi, Lord Toulson and Lord Hughes considered that the common law doctrine of secondary liability in criminal law, put into statutory form in Section 8 of the Offences Against the Person Act 1861, had taken a wrong turn. In their view, if it had been unduly widened by the courts, it was proper for the courts to correct the error. Similarly, in Knauer against the Ministry of Justice, where the Supreme Court held, departing from two earlier decisions of the House of Lords, that in a fatal accident claim for dependency, the multiplier should be calculated from the date of trial and not the date of death, Lord Neuberger was clear that as the pre-existing law had been made by judges and as it had been shown to suffer from defects, then, unless there was good reason to the contrary, it should be corrected or brought up to date by judges. To take some more recent examples, in two recent cases, the Supreme Court has radically reformed the law on reflective loss and the law on restraint of trade. In Seveleja and Maurex, it considerably reduced the scope of the principle of reflective loss, although not to the extent proposed by the minority in the court, who would have gone much further. In Peninsula Securities and Dunn's Stores, the Supreme Court put the law of restraint of trade on a new basis, departing from the decision of the House of Lords in Esso Petroleum and Harper's Garage. Those decisions of the Supreme Court brought about important changes in the common law. And while there may be room for differing views as to the merits of those decisions, I've not heard it suggested that it was inappropriate for the Supreme Court to act to reform the law in these areas at all. It does seem to me that the judges have a responsibility to maintain the common law as fit for purpose. And yet, quite apart from concerns about the democratic deficit involved in judges altering the law, there are substantial disadvantages which attend reform of the common law carried out by the judiciary. First, judges can only decide the cases that come before them. A judge who sets out with a mission to reform a particular area of the law may never be presented with the opportunity. In our adversarial system, what legal points are taken and how they're argued is to a large extent a matter for the parties, and it is they who decide whether or not to appeal. Not only do judges have to wait for a case to come before them which raises the issue, but even then, the facts have an irritating habit of getting in the way of the really interesting points of law. What is needed is the right case, by which I mean that it must be a suitable vehicle for reforming the law. In particular, this will require that the decision on the vital point will have the force of precedent and be binding on other courts and not merely an obiter dictum. Sometimes it can take many years for an appropriate case to come before a senior appellate court so as to permit effective judicial law reform. Some of you may be old enough to remember a very unsatisfactory decision of the Court of Appeal in Harwood's Plasticine Limited and the Wayne Tank and Pump Company Limited concerning exclusion clauses and a substantive doctrine of fundamental breach. We had to wait a decade for a suitable case to come before the House of Lords, Photo Production and Securicor, which enabled it to put the law back on a sensible basis. Conversely, in 2018, the Supreme Court heard an appeal, Rock Advertising Limited against MWB Limited, which raised not one, but two fundamental controversies in the law of contract. One, whether a contractual term precluding amendment of an agreement other than in writing is legally effective. And secondly, whether the variation of an agreement to pay money by substituting an obligation to pay either less money or the same money later is supported by the necessary consideration. On the first issue, the Supreme Court held that the parties could bind themselves by agreement as to the manner in which future changes in their legal relations were to be achieved. Accordingly, it held that the oral variation was ineffective. However, in these circumstances, the Supreme Court considered that it was both unnecessary and undesirable to deal with the consideration issue. The appeal raised full square the question whether the Court of Appeal was correct to hold in Williams and Roffey that an expectation of commercial advantage was good consideration, and how that conclusion could be reconciled with the decision of the House of Lords in Folks and Beer. In Rock Advertising, Lord Sumption explained that the reality was that any decision on this point was likely to involve a re-examination of Folks and Beer, which was probably ripe for re-examination. However, if it was to be overruled or its effects substantially modified, it should be before a larger panel of the court and in a case where the decision would be more than an obiter dictum. So a particular case before the court may not be the appropriate vehicle for judicial law reform. Secondly, it's often the case that what is required is not reform of a single rule, but a systematic reform of a whole area of the law. And here the disadvantages of judicial law reform become particularly apparent. The law of state immunity provides an example. Until the 1970s, English law adhered, erroneously we're now told by Lord Sumption in Benkebush, to a virtually absolute doctrine of state immunity. Following the Second World War, such an approach was increasingly out of step with the requirements of international law and the practice of other states, and was in danger of operating to the considerable disadvantage of English law and English jurisdiction. In a series of cases, the Philippine Admiral, Trentex and the Central Bank of Nigeria, and Primero Congreso del Partido, the appellate courts embarked on a bold and exciting judicial initiative to reform the law of state immunity. Had it been left to the judges, no doubt the common law would have arrived eventually at a satisfactory body of rules limiting the scope of immunity. But it would have taken an inordinate time to achieve, and during that time, the law would have been the subject of great uncertainty. In fact, what happened, of course, was that Parliament intervened, and the State Immunity Act 1978 introduced a structured and systematic reform of the law, which has stood the test of time pretty well. Here, legislation was clearly a much more appropriate way in which to achieve the urgently needed reform of the law. While law reform achieved by legislation can provide clarity and certainty, on the other hand, it can sometimes suffer from the disadvantages of rigidity and inflexibility. It can often be difficult or impossible to legislate in advance for a multiplicity of situations which may arise. The common law, by contrast, is inherently a much more flexible instrument. What the common law excels at is the incremental development of the law to meet changing needs. Judicial elaboration or fine-tuning of a developing common law rule through a series of cases has very real advantages. When I was a student, Professor Hampson used to tell us that the common law moves like a crab, not like a kangaroo. A third disadvantage of judicial law reform is the uncertainty it can bring. Departing from established precedent can create huge uncertainty in the law. Furthermore, the fact that judicial law reform is retrospective, we maintain, of course, the legal fiction that the judges are just declaring the law and are therefore merely expressing what it has always been, can be deeply unsettling to the legal order and disruptive of legal relationships entered into on a shared and entirely reasonable understanding of what the law was. Judge-made law may disturb retrospectively the basis on which contracts, settlements of property, and other arrangements have been made. As a result, a judicial decision to depart from established legal principles laid down by the House of Lords or the Supreme Court is never taken lightly. This operates as an important restraining influence. A fourth disadvantage of judicial law reform relates to the limited scope of litigation and the judicial process. The focus of litigation is necessarily on the case in hand. Counsel and the judges who hear the case can be expected to concentrate on the particular issues arising in the context of that case and to view the applicable law through the prism of that case. This is not necessarily a particularly sound foundation for a general reform of the law, which will require the court to take account of the wider implications of such a change, as opposed to its implications in the particular context before it. Furthermore, the judge is usually dependent on counsel and solicitors to research the issues, and they may have little incentive to address a range of wider issues which do not necessarily have a bearing on the case before the court. Judges in the Court of Appeal and in the Supreme Court now have judicial assistants who can assist in researching the law. However, the process of litigation does not allow for wider research, for example, into the social, technical, or economic consequences of a proposed reform of the law. There is, on occasion, a need for wider empirical research to assist in the reform of the law by the judiciary. And it is here, it seems to me, that there is an important role for the Law Commission. The Commission has vast expertise and experience in carrying out law reform projects. In particular, it has a particular expertise in carrying out research and in consulting the public on proposals for law reform. It is particularly well placed to advise on the wider consequences of law reform carried out by the judiciary. It can provide a broader view than might otherwise be available. As my colleague Lady Arden has observed extrajudicially, a Law Commission report can be of great value in influencing judicial development of the law. The great American judge, Benjamin Cardozo, wrote that if there was no prior case law on a point, he would consult the social mind. And Lady Arden asks, where better to find such information than in a report of the Law Commission on which the public and professions have been consulted? There have been strong links between the Law Commissions and the Supreme Court since the creation of the Supreme Court, and the dialogue between them has taken many different forms. In the first 11 years of its existence, that is from October 2009 to July 2020, the Supreme Court referred to the Law Commissions in 85 out of the 733 judgments it delivered. That is, in approximately 12% of its decisions. This is perhaps unsurprising, given that 4 current and 3 former justices of the Supreme Court have previously been law commissioners. The Supreme Court uses Law Commission materials to clarify the current state of the law. Professor David Ormrod, who was a colleague of Francis's and mine at the Commission, argues that this forms an important part of the symbiotic relationship between the courts and the Law Commissions. With regard to the Law Commission of England and Wales, he notes that while the courts can serve as superb reviewers and sometimes promoters of the Law Commission's work, the Commission in turn provides high quality, reliable, accessible sources of law for the courts to draw upon. The Supreme Court also regularly refers to the Law Commission's reports to assist it in interpreting legislation that has resulted from the Law Commission's recommendations. As Lord Justice Clark put it in Yaxley and Gotts, where a statute has been enacted as a result of the recommendations of the Law Commission, it is both appropriate and permissible for the court to consider those recommendations in order to help it to identify both the mischief which the Act is designed to cure and the public policy underlying it. In this way, the Law Commission's reports can assist the court's interpretive function. Although courts have no power under the Law Commissions Act to refer an issue to the Commission, they are an important source and inspiration for Law Commission projects. Professor Ormrod again observes, in a general sense, the courts have a constant influence on the Commission's reform agenda by exposing the deficiencies in the law, creating the opportunity for others to suggest projects for the Commission. More relevant to this debate are those occasions when a judgment makes explicit reference to the need for the Commission to take on a project. Sometimes a judge will make a direct appeal in a judgment to the Commission to undertake a particular project. The Commission's current project on the proceeds of crime came about in that way, following a suggestion by Lord Hughes in Gooraj. In the same way, the Commission's project on misconduct in public office was prompted by the judgment of Lord Justice Leveson in the Court of Appeal in DL. On other occasions, a judicial decision may prompt the government to ask the Law Commission to review a particular area of the law. And that's what happened following the Supreme Court decision in Cheshire West, which gave an expanded interpretation of deprivation of liberty in a health and social care context. At the government's request, the Law Commission reviewed the law and in its final report called for the deprivation of liberty safeguards to be replaced as a matter of pressing urgency and proposed a replacement scheme. The Supreme Court sometimes expresses support for ongoing Law Commission projects or endorses Law Commission recommendations for reform. As Dr. James Lee recognizes, sometimes this support is express and sometimes more oblique. It should not be thought, however, that Supreme Court comment on Law Commission projects is invariably favorable. In ILOT and the Blue Cross in 2017, Lady Hale was critical of the failure of the Commission to reconsider the fundamental principles underlying claims by adult children under the Inheritance, Family Provision and Dependence Act 1975, when it last dealt with the topic in 2011. It now seems clear that the Law Commission has an important role to play in the judicial development of the law. Lady Hale has observed extrajudicially that it is a fascinating idea that the Law Commission itself could stimulate judicial law reform by providing a fully researched, reasoned, and consulted upon policy case for developing the law in a particular area in a particular way. In recent years, the dialogue between the Commission and the appellate courts has resulted in significant instances of law reform by the judiciary. Lady Hale has suggested that the Law Commission working paper on rape within marriage may be the first example of the appellate courts adopting Law Commission recommendations which were addressed to Parliament. She said this, somehow or other, between the publication of the working paper in October 1990 and our report in January 1992, both the Court of Appeal and the House of Lords had persuaded themselves that they could abolish the marital rape exemption without parliamentary intervention. Neither judgment mentions the powerful case made in the working paper, a joint effort between the criminal and family law teams, but it is difficult to believe that their lordships had not read it. Well, she may well be right in that. However, there are many more recent examples. In its consultation paper on double jeopardy, published in 1999, the Law Commission addressed the decision of the Privy Council in Sambasivam and the public prosecutor, a case from Malaysia, which prevented the prosecution in criminal proceedings from making an assertion which was inconsistent with a previous acquittal. In the Commission's view, the rule had two distinct applications. To the extent that it prevented the prosecution from bringing another charge inconsistent with the previous acquittal, it merely reiterated the rule against double jeopardy and was redundant. To the extent that it applied where the charge laid was not itself inconsistent with the previous acquittal, but where the prosecution sought to adduce evidence which, if accepted, meant that the defendant must have been guilty of the offence of which he'd been acquitted, the Commission considered that it could not be justified. In the consultation paper, it therefore provisionally proposed that, subject to the rule against double jeopardy and the rules on the admissibility of evidence of a defendant's previous misconduct, the rule in Samba Sivem should be abolished. After publication of the consultation paper, but before the publication of the Commission's report, the House of Lords in Z, expressly relying on the Commission's consultation paper, abolished the rule in Samba Sivem in England and Wales. And as a result, similar fact evidence relating to 3 previous offences of rape, of which the defendant had been acquitted, was held admissible at his trial on a further charge of rape. In other cases, the courts have adopted Commission recommendations addressed to them specifically. For example, in its 1998 report on damages for personal injury, the Law Commission recommended that the court should increase the level of general damages for pain, suffering, and loss of immunity awarded in personal injury cases by significant percentages. In 2000, in Hyle and Rankin, a specially constituted 5-member Court of Appeal was convened expressly to consider the issue in a judgment on a number of appeals. The court accepted the Commission's broad approach and partly implemented its recommendations for a general uplift in these damages, although the result was a lower increase than the Commission had recommended. Similarly, in Knaar and the Ministry of Justice, the Supreme Court in 2016, as I've already mentioned, held in a fatal accident claim for dependency, the multiplier should be calculated from the date of trial and not the date of death. And in doing so, it expressly followed a recommendation of the Law Commission in its report on claims for wrongful death. As a result, dependents in fatal accident cases should receive that which reflects their probable loss on an actuarial calculation based on the facts known at the date of trial. Reform of the law was achieved by the judges in a rather different way in the case of the Law Commission's report on expert evidence in criminal proceedings, published in March 2011, in which it recommended a new admissibility test for expert evidence in criminal proceedings. It was published against a background of concern that expert evidence was being admitted too readily with too little scrutiny. The report was accompanied by a draft Criminal Evidence Experts Bill, which set out an admissibility test that judges would apply to exclude unreliable expert evidence. In November 2013, the Ministry of Justice responded, indicating that it did not intend to act on the majority of the Commission's recommendations at that time. However, the judges came to the rescue, and a great deal has been achieved by other means. In Stephen H. against the Queen, a case in which Mrs. Justice Patterson sat with Sir Brian Leveson, President of the Queen's Bench Division, and Sir Richard Henriques, dismissing an appeal against conviction from His Honour Judge Mansell, Queen's Counsel in the Crown Court at Manchester, rather a Northern Circuit affair. The court noted that while legislative reform, as recommended by the Law Commission, was not being taken forward, there was real concern about the use of unreliable or inappropriate expert evidence. Therefore, the criminal procedure rules and practice directions were being revised in order to incorporate the reliability factors recommended by the Law Commission for the admission of expert evidence. In this way, the Criminal Procedure Rules Committee adopted as many of the recommendations as it could. In the result, the common law remains the source of the criteria by reference to which the court must assess admissibility, but the Criminal Procedure Rules list the matters which must be covered in the expert's report so that the court can conduct such an assessment, and the practice directions list the factors that the court may take into account in determining the reliability of expert opinion. As the Lord Chief Justice, Lord Thomas of Cumgierth, observed in his 2014 Calendar lecture, this is plainly a novel way of implementing an excellent report. Two parallel developments are also particularly worthy of note here. First, in a series of cases concerned mainly with the use of low template DNA, the courts have established the principle that expert evidence can be admitted only if it is reliable. And secondly, the Advocacy Training Council adopted the Law Commission's recommendations in this report. And these recommendations continue to inform the guidance issued by its successor, the Inns of Court College of Advocacy. As a result, the Law Commission can claim with confidence that the entire approach of the profession to expert evidence in both criminal and civil proceedings has now been fundamentally reformed, and the risk of miscarriages of justice greatly reduced as a result. Clearly, there is more than one way of achieving law reform. A particularly striking recent example of judicial law reform in this jurisdiction has been the reform of the illegality defense at common law by the Supreme Court in Patel and Mirza. That reform followed strong disagreement within the Supreme Court as to the path which the law should follow, and the eventual outcome was inspired by the work of the Law Commission. It had long been the case that, setting to one side cases where the illegality arose from a statute, the position of common law, which attempted to distinguish between illegality in formation and illegality in performance, was unclear and imprecise. The illegality defense had been considered by the House of Lords in Tinsley and Milligan in 1974. That case established a rather mechanical rule that a party to an illegal agreement could not enforce a claim against the other party to the agreement if they had to rely on their own illegal conduct in order to establish the claim. There were difficulties with that approach, however. Its emphasis on procedural matters and the fact that it was often quite fortuitous whether a party had to rely on his or her own illegality in order to prove the claim. Lord Gough, who dissented in the House of Lords in Tinsley and Milligan, considered that reform should be instituted only by the legislature after a full inquiry by the Law Commission, which would take account of the advantages and disadvantages of the present system and of a discretionary system. The Law Commission included the illegality defense in its 6th programme of law reform. In 1999, it published its first consultation paper on the subject, in which its provisional proposal was for legislation by which the courts would be given a structured discretion to decide on what should be the impact of the claimant's illegality on an otherwise valid claim. This proposal was very much on the lines of the New Zealand model. Following that, however, the Commission reconsidered the matter, and in 2009, it published a further consultation paper, and in 2010, a final report. That report recommended statutory reform in relation to the illegality defense in the context of trust law. That came to nothing because in 2012, the government announced that it did not intend to take forward the Commission's proposal for statutory reform of the law relating to trusts, as it did not consider it to be a pressing priority for the government. In relation to the law of contract and unjust enrichment, however, the Commission's 2010 report recommended that the illegality defense was best tackled by a process of judicial development, which could make the law clearer and less arbitrary. It had changed its position as a result of the responses to its further consultation and further judicial decisions. The Commission was very critical of Tinsley and Milligan and the cases following it, which it considered exemplified the problems of arbitrariness, uncertainty, and potential for injustice. It considered that the courts should balance the various policy considerations in play in deciding whether the denial of the claimant's claim was a proportionate response to the claimant's illegality. And it identified the principal policy rationales for the illegality doctrine as furthering the purpose of the rule infringed by the claimant's behavior, consistency, prevention of profit from the claimant's wrongdoing, deterrence, and maintaining the integrity of the legal system. The scene then shifts to the courts, and in particular to the Supreme Court. Many doubted whether the judges could bring about the necessary reform in this area, and indeed, the course of this particular judicial law reform did not run smooth. In Laboratoire Servier and Apotheques, and Parking Eye and Summerfield Stores, the Court of Appeal followed the approach of the Law Commission. In Parking Eye, Lord Justice Toulson observed that it is better and more honest that the court should look openly at the underlying policy factors and reach a balanced judgment in each case for reasons articulated by it. There then followed in quick succession a series of cases in the Supreme Court. In Hunger and Allen, Miss Hunger, a 14-year-old Nigerian, had entered the United Kingdom under false pretenses, had overstayed, and had illegally been employed by Mr. and Mrs. Allen, who had assisted her in obtaining false identity documents. Miss Hunger was ill-treated and subsequently dismissed by her employers. The Court of Appeal dismissed her claim for the statutory tort of unlawful discrimination under the Race Relations Act 1976 on the ground that it was tainted by the illegal nature of her employment. However, the Supreme Court reversed this decision. Lord Wilson, giving the leading judgment, considered that the solution lay not in asking whether the claimant needed to rely on an illegal contract, but on the foundation of public policy. Weighing the policy considerations, he concluded that the public policy considerations in favour of applying the illegality defence so as to defeat Miss Hunger's claim scarcely exist and should give way to the public policy to which its application would be an affront. In Laboratoire Servier and Apotheques, a claim to enforce a cross-undertaking in damages on the grant of an interlocutory injunction, so a claim akin to a contractual claim. And while the Supreme Court unanimously upheld the decision of the Court of Appeal, the majority expressed the view that the Court of Appeal's decision could not possibly be justified by the public policy considerations it had put forward, which had broadly followed the recommendations of the Law Commission. Lord Toulson, as he had by then become, agreed that the appeal should be dismissed, but observed that the Court of Appeal was right to take public policy considerations into account and had adopted a similar approach to that taken by the Supreme Court in Hunger and Allen. Then, in Bilter and Nazir No. 2, there was a sharp division of views within the Supreme Court as to the proper approach to the defence of illegality, which it was not necessary to resolve in that case. However, the President, Lord Neuberger, considered that it needed to be addressed as soon as appropriately possible. The opportunity soon presented itself. In Patel and Mirza, Mr. Patel transferred £620,000 to Mr. Mirza for the purpose of betting on the price of shares using advance insider information which Mr. Mirza expected to obtain. Mr. Mirza's expectation was mistaken, and the betting did not take place. Mr. Mirza failed to repay the money to Mr. Patel, who then sued to recover the sums which he'd paid. A Supreme Court of 9 justices held that the sum was recoverable. The real significance of the decision for present purposes, however, is that by a majority of 6-3, the Supreme Court held that the essential rationale of the illegality defence is that it would be contrary to the public interest to enforce a claim if to do so would be harmful to the integrity of the legal system or possibly certain aspects of public morality. The rule in Tinsley and Milligan that one could not enforce a claim if one had to rely on one's own illegality did not satisfy the requirements of coherence and integrity of the legal system and should no longer be applied. The kernel of the new approach to illegality of common law is stated by Lord Toulson. He said this: "So how is the court to determine the matter if not by some mechanistic process? In answer to that question, I would say that one cannot judge whether allowing a claim which is in some way tainted by illegality would be contrary to the public interest, because it would be harmful to the integrity of the legal system, without A, considering the underlying purpose of the prohibition which has been transgressed, B, considering conversely any other relevant public policies which may be rendered ineffective or less effective by denial of the claim, and C, keeping in mind the possibility of overkill unless the law is applied with a due sense of proportionality. We are, he said, after all, in the area of public policy. That trio of necessary considerations can be found in the case law. Well, it's somewhat unusual in the field of English private law for judges to be called upon to balance policies in quite the way required by the decision in Patel and Mirza. However, the need for such an approach is a reflection, I would say, of the fact that here the court is not simply seeking to do justice between the parties, but it's also required to maintain the integrity of the legal system itself. And maintaining the integrity of the law in this area requires a flexible approach, such as that which has now been arrived at. In two more recent decisions, Stoffel and Grondona and Henderson and Dorset Healthcare University Foundation Trust, the Supreme Court has provided some further guidance as to how Lord Toulson's trio of considerations should be applied. But the basic principles are stated with great clarity in the judgment of Lord Toulson in Patel. And in the result, we have a striking example of judicial law reform inspired to a large extent by the work of the Law Commission, whose views had been largely shaped and informed by its extensive consultations. Admittedly, it took some time to achieve, but in my view, it was worth waiting for. There's some evidence that difficulties in securing law reform by legislation are leading to a change of approach on the part of the Law Commission in some areas. In January 2018, the Commission started a project on electronic signatures as part of its 13th programme of law reform, the purpose of which was to address any uncertainty as to the formalities around the electronic execution of documents, and to ensure that the law governing these formalities was sufficiently certain and flexible to remain competitive in a post-Brexit environment. The project focused on the use of electronic signatures to execute documents where there is a statutory requirement that a document must be signed, and the electronic execution of deeds, including the requirements of witnessing and attestation and delivery. The project did not extend to wills or to registered dispositions under the Land Registration Act 2002. At the outset of the project, it had been the intention to produce a draft bill in order to secure reform by legislation. However, the Commission became increasingly concerned on two grounds: that a legislative solution might not be a necessary or the most elegant solution, and that lack of parliamentary time might result in the report and draft legislation languishing. In its report published in July 2019, the Commission found that domestic and EU law does accommodate the use of electronic signatures through a combination of existing legislation and case law, but that this is not to be found in a single source, with the result that the law is inaccessible to many. The Commission therefore prepared a short statement of the law, setting out its conclusions as to the validity of electronic signatures. In particular, it considered that an electronic signature is capable in law of being used to execute a document, including a deed, provided that the person signing the document intends to authenticate the document and any formalities relating to execution of that document are satisfied. Furthermore, an electronic signature is admissible in evidence in legal proceedings, inter alia, to prove or disprove the identity of a signatory or the signatory's intention to authenticate a document. Taking as its starting point judicial decisions in which various non-electronic forms had been held to be valid signatures, the Commission considered that there's no reason in principle why electronic equivalents to these forms of signature should not be recognized by courts as legally valid. And this statement is of broad application and not limited to either commercial or consumer documents, and it's supported by a more detailed analysis of the law later in the report. The Commission, therefore, did not recommend legislation because the common law already accommodated electronic signatures, although it did suggest that the government might wish to consider codifying the law in order to improve its accessibility. the statement within the report of the Commission's understanding of the current law will be extremely useful both to the courts and to the public at large. I've already referred to the way in which the courts use Law Commission reports as reliable and accessible statements of the current law. But of particular interest in the present context is the Commission's conclusion that, to the extent that there may be ambiguities or uncertainties in the law, it is open to the common law and to the courts to resolve such ambiguities or lacunae. This report therefore provides further evidence of the symbiotic relationship between the courts and the Law Commission. I understand that the report has been well received and that there is currently no pressure for legislation in this field. It seems that the Commission may consider adopting a similar approach in some of the other areas which it is currently reviewing, for example, smart contracts or digital currencies. The Commission's recent call for evidence on smart contracts will inform a scoping study on the ways in which smart contracts are being used and the extent to which the existing law can accommodate them. So, to conclude, I would draw a number of conclusions. First, traditionally, the Law Commission has focused its work on achieving law reform by parliamentary legislation. Parliament has adopted and developed machinery appropriate for the achievement of law reform by legislation, but there remain substantial obstacles of lack of parliamentary time and the fact that often in this country, as elsewhere, law reform does not always receive the priority it deserves. Secondly, there are many disadvantages in law reform achieved by judicial action. I've mentioned the democratic deficit. The retrospective character of reform of the common law by the judiciary can introduce uncertainty into the law. The opportunity for judicial law reform may be fortuitous, depending as it does on litigation largely under the control of the parties. But in appropriate cases, judicial law reform has the advantages of flexibility and subtlety. Unlike legislation, judicial law reform speaks not only from a particular moment, but can evolve over time. Thirdly, there are occasions when law reform is urgently required if the law is not to become out of touch with modern conditions or to fall into disrepute. There is also a responsibility on the judges to maintain the common law in good working condition, in condition which is fit for purpose. In these circumstances, reform by the judges will be justified and beneficial. Fourthly, one particular disadvantage of judicial law reform arises from the inability of judges to carry out empirical research. This can be mitigated to a substantial extent by the work of the Law Commission in researching and consulting on its proposals for law reform. The Law Commission is showing an increasing willingness to assist the judiciary in keeping the common law up to date. This is a very welcome development, and this refocusing will add an important new dimension to the role of the Law Commission. Fifthly and finally, I would suggest that the Law Commission is a great national asset which is underappreciated. Over the 55 years of its existence, it has established itself as an invaluable and indispensable part of our legal system. Time and again, in its proposals for reform of our law, it has shown wisdom and resourcefulness, qualities epitomized by Francis Patterson, whose life and work we gratefully commemorate this evening. Thank you.
David, thank you for that presentation, that lecture, which takes us very much up to time. So I'll just say a few final words. I first came across Francis in the first case I was instructed in, which was Manchester Airport second runway inquiry back in 1994. That was the second runway, the most important thing really to come to Manchester since Alex Ferguson. And Francis was tasked, while still a junior, with being the lead counsel for the City Council who were in support of that scheme. My role as a pupil was rather more modest, mainly concerned with pouring the champagne for Lionel Reed QC. She went on to be somebody who I dealt with both as a as an opposing advocate, as a judge, as a fellow member of the Society for Advanced Legal Studies Planning Law Reform Working Group while she was still at the bar. And she made a huge compact and a huge impact. I saw her, she had a very sort of laid back style, saying something if it didn't really seem to matter, but was utterly devastating to whatever particular point it was she wanted to get over. And with Miss Frances, we also, thinking back to the Manchester inquiry, Miss Andrew Gilbart, who was the second QC for the airport in that scheme and took over for the airport partway through. Again, he too went to the High Court bench, and again, he too left us far, far too soon. But David, thank you for your presentation and for explaining how the role of the Law Commission and what it's achieving move on. In the Law Commission, we tend to think of in terms of its role with government and encouraging government in law reform. Now, I find getting the civil service to pursue law reform, which they're not interested in, is difficult. If the civil servants aren't interested in it, then unless the ministers are interested in it, government tends not to do that. And usually with both the civil service and ministers, the question with any law reform proposal is, well, is this a practical effect? Is there a point in doing it? But when a case comes in front of the courts, which requires these issues to be looked at, it clearly is of practical importance. The issue has arisen in some form in that litigation. And the nature of responsibility of the courts is to resolve that particular issue, but with the common law, its effect as a wider precedent and to quite often to shift dramatically how we deal with things. A problem with that which you identify, of course, is that the judges and the parties are concerned with the facts of that case, and for the parties, the issues as they appear to them to secure what they're seeking to achieve. The Law Commission's work is able, as you suggest, to give a wider context and a wider range of views, which may help inform what the court does. We often, though, of course, wait for the cases to come up, and they may come up in good time, or it may take a long time since any of us have thought of a particular bit of law reform that's worth doing. It may be 10 years before a particular case drops on our desk or in front of us. Now, the role of the judges in moving the law on, I think, has become an often theme in lectures. It was a theme in Baroness Hale's first memorial lecture for Frances Patterson in 2019, where she responded to Lord Sumption's Reef lectures and the debate which arose then. I suspect it's going to be a theme in quite a few of these lectures to come. So, David, thank you very much for your lecture. It will be available as a recording, I think, probably on the King's Chambers website, and we can look at it further in due course. Thank you to those organising both at King's Chambers and 39 Essex Chambers, and for the support of the Planning and Environment Bar Association. Thank you, everyone, for attending and watching. Apologise that whilst you've been watching David, also the misfortune to have to stare at a still image of me. We'll try and get the technology a bit better behaved in future if we come to it. But more importantly, I hope that in future and for the third lecture, we will be able to meet in person and to together share a drink and a discussion afterwards about what's been said in that lecture and about the huge work and the great personality of Frances Patterson. But thank you very much. Everyone enjoy what seems to be a very sunny and pleasant evening. Goodbye.